Hello, everybody. Welcome to the Lunch Speaker Series that is co-sponsored by the John Locke Foundation and the Triangle Chapter of the Federalist Society. Our speaker this month is Jason Kay, who earned his law degree with honors and a Master of Public Administration degree from the University of North Carolina at Chapel Hill. Jason has also earned a Master of Science and Bachelor of Science degree from Indiana University. He has practiced as corporate counsel at Laboratory Corporation of America Holdings, a litigation partner at Sawyer & Kay PLLC, and law clerk for Justice Mark Martin at the North Carolina Supreme Court, in addition to his current position with the North Carolina Institute for Constitutional Law. He is here today to speak about the case of Libertarian Party versus State and the ballot access issues that it raises. We are honored to have him here at our speaker series. The Federalist Society is a society for both lawyers and non-lawyers that sponsors events on issues of importance to the legal community. If you're interested in learning more, please see me or sign up at the desk out front. If you're interested in learning more about the John Locke Foundation, please see the brochures that are available at front or see Darren Baxt, who's over here. And now let me welcome Jason Kay.
Thank you, Robert. Let me get wired up here. Reminds me of my days before I was in the witness protection program. Not really. It sounds mysterious, though, doesn't it? Well, it is my pleasure to be with you over the lunch hour here. I see Chief Justice Lake is here and Judge Calabria. Thank you for coming. She wrote the dissent, so if I'm wrong, she will let me know about any of the things in the case. How many of you all, before I get started, are lawyers versus non-lawyers? I want to understand how technical to be. Okay, good enough. Thank you. All right. Well, I want to begin with a fictional story about a newly minted graduate of law school from the northeastern part of our country who comes down to somewhere in the South, not unlike North Carolina, and on his travels to wherever he is going, he passes a stop sign at which he neglects to stop. He slows down a little bit, proceeds on through, and not too long he sees blue lights in the rearview mirror and pulls over. The deputy comes up and says, "Sir, where you ran the stop sign?" He says, "Well, no, I thought I slowed down." He says, "Well, no, sir, it says stop." Now, at this point, the newly minted law graduate begins to become a little full of himself and think that perhaps his legal acumen is more impressive than it really is. And so he decides he's going to have a little fun with the deputy. And he tells the deputy, I tell you what, if you can tell me the difference legally between stop and slow down, you give me a ticket, I go on my way. If you can't, then you just leave me go and we'll both have a nice day. Now, the deputy, slightly irritated with this challenge to his authority and frankly just irritation in doing his job day to day, says, "All right, son, step out of the car, please." Says, "All right," steps out of the car. The deputy quickly draws his nightstick and begins to beat him about the legs and waist. The man drops to the floor and starts screaming, "Stop! Stop!" And the deputy leans over and says, "Now, son, do you want me to stop or just slow down?" I tell that story, one, because I think it's funny. Two, because it illustrates a little bit of a distinction that's at play in almost every constitutional case. And it's the distinction between the plain, regular, normal meaning of words that you and I bat about every day in our English language and the constitutional meaning of those words. They're different things. Maybe at one time they were commonly understood, but over time judges and courts have had to construe the meaning of these words and have given them definition in particular contexts and laid out tests. And then later courts have had to come and give definition to the tests that have laid out the words in the Constitution and so on and so forth, to the point where sometimes the words in the Constitution do not mean what they look like they mean to you and I. And sometimes they do. Sometimes they mean exactly what they mean. But that's the case in every constitutional issue that we deal with. And so the challenge is figuring out, digging into the legal dictionary of concepts and meanings of words to determine whether a particular action by the state is in fact outside the bounds of the Constitution, such that it has no authority to engage in that particular activity. Well, some of you are familiar with the facts of the case that we have as a topic for today. The Libertarian Party of North Carolina versus the state. And in that case, a number of constitutional provisions are at issue, several of them. But the basic issue is whether the ballot access laws which apply to the Libertarian Party of North Carolina as a third political party, not one of the major two, are those discriminatory in a way that is violative of the Constitution? Do they make distinctions? Do they draw lines in a way that's impermissible under the Constitution of North Carolina? Not so much of the United States of America. Well, let me run through a little bit of case history first to bring you up to speed. On September 21st, 2005, this case was filed in the trial court. And I thought it would be fun to reminisce a little bit about what was going on in 2005, since that may be a long time in the rearview mirror. And so I went through some headlines. I had our crack research division, which we call Cynthia, who's very, very good at this. And she put together a few headlines from that particular day. Friends and colleagues celebrate the life of Peter Jennings. He had died about 6 weeks prior. Hussein will not be allowed to represent himself at trial. Native American ban extended by the NCAA. Senator Harry Reid to vote against John Roberts. One suspects that decision was made before September 21st, 2005, but that's the date it was announced. Iran warns of referral of nuclear issue to the UN. I hope that doesn't take too long to resolve. And the last one was skipping law school. Lincoln did it. Why not you? Some of you may feel like that. Well, not too long after the Libertarian Party filed its complaint, the Green Party intervened as a party, as a plaintiff in the case. And in late May of 2008, the trial court, after a bench trial, no jury was involved, entered a judgment in favor of the state. That made its way through the procedural hoops and such and so forth. And on October the 20th, 2009, just a few months ago, the Court of Appeals issued a split decision. 2-1. The two were Chief Judge Martin and Judge Steelman. The one was here, Judge Calabria. And it answered the question essentially 2-1 in favor of the state. There are a few nuances that I think are really, really important. Not just to understand about this case, but about constitutional law in general. We need to understand the test that was applied. What posture did the court bring to analyzing this state action, which created different levels of ballot access as applied to the Libertarian Party than as applied to the Democrats and the Republicans? Technically, the law is neutral on its face, but it applies differently to the two separate groups of established parties and non-established parties. Two issues are involved in this. One is ballot access, one is ballot retention. For purposes of the suit, and what I'm going to talk about today, most importantly, I'm going to boil it down a little bit. It's not critical, but just please understand that there is a difference between getting on the ballot and staying on the ballot. Well, here are the facts of that case, as agreed by the parties and as discussed by the Court of Appeals. If the Court of Appeals in some place disagrees with what the party said, I've gone with what the Court of Appeals has said. First of all, you need to understand that from 1935 to 1981, with regard to access to the ballot, to get a candidate on a ballot, a political party needed to get the signatures of 10,000 registered voters. 1935 to 1981. Well, what happened in 1981 that changed that? Well, it could have been the sense of fairness and propriety of the legislature. They just thought the world needed to be a fairer and more just place to live, but not really. The Socialist Workers' Party got on the ballot in 1980, and back then socialism was a scary thing. And the legislature, for reasons that are not fully clear, changed the requirement to 5,000 names, but also required that if you signed the petition your party registration, your party affiliation was automatically changed to that party. So previously you could be a member officially with a political party, but if you signed the petition to get another party on the ballot, your name was automatically enrolled in the whatever list that that party had. Well, that provision was struck down in 1982 because we have a First Amendment, and also in 1982 we had another election. So that part was struck down. We had a threshold of 5,000 signatures. 1982, all you had to do to get on the ballot was have 5,000 signatures. We had 4 parties on the ballot in 1982. They were the same 4 parties that were on the ballot in 1980 when the requirement was 10,000 signatures. So understand, we had a shift, it went lower, there was no substantive change in who was on the ballot. Then in 1983, the law was changed to require 2% of the number of voters who voted in the last gubernatorial election. That was the ballot access threshold as of 1983. In 2008, this translates to roughly 70,000 signatures in order to get on the ballot. Now, I want to put this in context. I've not done this research personally, but it has appeared in the briefs. Based on experts and other research information, in the entire history of the United States, there are only 5 instances in which a new political party has been able to collect that many signatures. Entire history, that many for a new political party. That's the threshold that we have here. That requirement is also approximately 5 times higher than the median percentage requirement in the United States for a new political party. That's what we have in North Carolina. The Libertarian Party spent nearly $130,000 to get these signatures, and a good chunk of time and focus from the gubernatorial candidate, Mike Munger, was spent to generate those signatures. And even with all the fundraising at the state level, they only got to about 60% of the amount of funds they needed to expend to get those signatures. The National Party kicked in another roughly 40%. So that's ballot access. Ballot retention. From 1935 to roughly 1949, 3% of the statewide vote was required to stay on the ballot. Then a party called the States' Right Party polled at 8.8%, and it was changed to 10% in 1949. The 10% requirement remained from 49 until after this suit was filed. It used to be 10% to stay on the ballot until after this suit was filed. In 2007, the retention requirement was lowered to 2% of the vote, so it's now balanced. 2% to get on, 2% to stay on. If you're not a political party, here's how you get on the ballot. For a statewide office, 2%. For a local office, if you're unaffiliated, 4% of the registered voters in that district. Or if you're a write-in candidate, 500 registered voters. 500. The question is not so much whether or not the state is allowed to erect certain barriers to access to the ballot. Not everybody in the world should be on the ballot. They haven't asked that question. That might be a good debate to have under the North Carolina Constitution, but that's not the debate that was present in this case. The question is whether drawing the line between a ballot-worthy political party and just a plain old political party has been drawn in a way that's consistent with the Constitution. What the court has said, and in light of some prior cases, we're just leaving off the question of whether or not that's allowed to be drawn in the first place. That any distinction at all, that's not so much the question. Please understand that. The question is more where the line is to be drawn. And I want to pause for a second to go to a side issue that I think is really important. It's not the focus of what we'll be talking about today, but it at one point was a focus of part of this case. The side issue is the distinctions between ballot-worthy party and just plain old party. They have more ramifications than what's at issue for the present election. It's not just who gets on the ballot. Here's some other things that are affected by whether or not you get on the ballot. The State Board of Elections is composed of, and I quote, a list of nominees submitted to the governor by each of the 2 political parties having the highest number of registered affiliates. The State Board appoints 100 county boards of election. They are given essentially an unfavorable placement on the ballot. A political party also cannot allow registered voters of another party to vote in its primary. If you've declared and you're registered for another party, you have to stick with that party. There's some boundaries that are erected. This is curious to me. There's an involuntary change of voter registration, involuntary, for persons affiliated with a political party if that political party is decertified. Every year, if you don't meet the 2% threshold, you are involuntarily unenrolled from your registration and you have to re-enroll. Wonder how that would work if we use that for all the political parties. There's an exclusion of parties other than the Democratic or Republican parties from public funding, tax dollar funding. And this is the part that I find most interesting, especially in light of recent events. North Carolina General Statute 163-278.13 sub A says, no individual, political committee, or other entity shall contribute to any candidate or other political committee any money or make any other contribution in excess of $4,000 for that election. You all are familiar with this requirement. What you may not be familiar with is subsection E, a few lines down, which says, except this limitation does not apply to any national, state, district, or county executive committee of any political party, and then says political party means you have to get 2%. What this is doing is it's allowing unlimited contributions by the executive committee of political parties who qualify. That does not apply to anybody who doesn't get 2% of the vote. If you follow the reasoning, and I read that on purpose because it's easy to get lost and it's much harder to explain to the public what's happening, there's a massive exception in place for the 2 prominent political parties. Third parties don't get that privilege. So drawing of the line between what's a real political party, an official recognized political party under these statutes, and what's just a little p political party, it's a big deal. It has more attached to it than whether or not you get on the ballot. But I'm not going to talk about that anymore. I'm not going to focus on that. I'm just going to focus on the access and retention. This lawsuit raised a variety of claims under the North Carolina Constitution. Primarily the ones that were at issue in the Court of Appeals decision involve the freedom of speech, freedom of association. There are others that were at play, equal protection of the laws. There are some rights under Article 6 which pertain to the elections. One of them especially is interesting. If you read Section 6 of Article 6, it talks about how you become eligible to elective office, and doesn't say anything about party requirements, etc., so on. It just talks about you need to be 22 years of age, you need to be qualified by this Constitution, and you shall be eligible for election by the people to office. Some people may say, well, they are eligible to election. We just don't know about it. Well, how eligible is that if nobody knows? Well, the court, in answering these questions, had to the very first watershed decision that the court had to make was whether or not any of these constitutional provisions gave fundamental rights that were infringed upon by these differing ballot access statutes. Question 1 is there a fundamental right? Not all rights under the Constitution are equally protected. Some are more protected than others. Fundamental rights are heavily protected. So is this a fundamental right? If it's not, then rational basis review applies. Essentially, and I can go into the details later, but that usually means the government wins, usually. If it's rational basis. They just have to come up with a rational reason for what they want to accomplish, and ta-da, government wins. If it's a fundamental right, if the court says yes, then strict scrutiny applies. Some of you all know strict scrutiny, you've read about it, you hear of it. It basically means the government loses basically. It means, and I'll be more specific here, that the governmental interest advanced by the statute has to be compelling, a compelling government interest, as opposed to rational basis where it just needs to be a legitimate government interest. Secondly, it needs to accomplish that interest with means that are narrowly tailored. These are the words that we're dealing with, narrowly tailored to accomplish that interest. And lastly, and this is sometimes conflated into the narrowly tailored portion, but it has to use the least restrictive means. If there's another way to do it out there that's less restrictive constitutionally, you have to do it. In strict scrutiny, in other words, the court really digs into what has happened. It really closely examines what the legislature has done, what it's said, whether it's reasonable, whether it's compelling, whether it's narrowly, it really gets down there with a magnifying glass. Well, since the state won, some of you might think, well, of course, they didn't decide that it was a fundamental interest or a fundamental right at stake, but they did. They said, yes, it's a fundamental right. So therefore, strict scrutiny was triggered, and the court had to determine whether or not it was a compelling interest and whether it was narrowly tailored. Unanimously, the court said there is a fundamental right at stake. This infringes on a fundamental right. Unanimously, 3-0. The court then went on in a 2-to-1 split to say, having found that there's a fundamental right, we now apply a presumption that the statute enacted by the legislature is constitutional. A presumption. You know, race of 100 yards, you get to start at yard 30. Another good analogy of the presumption is in an art judging contest, one is presumed to be the best piece of art and the other one is not. So go ahead and get started and explain to me, if you can, how you get over the presumption that one is the better piece of art than another. In legal words, and I want to quote this language because I think this is powerful. This court presumes that any act of the General Assembly is constitutional and resolves all doubt in favor of its constitutionality. That's what the court does when a presumption is in place. And they applied the presumption of this case. Another way to say it, and this is also in the court opinion, the majority opinion, in challenging the constitutionality of a statute, the burden of proof is on the challenger, and the statute must be upheld unless its unconstitutionality clearly, positively, and unmistakably appears beyond a reasonable doubt, or it cannot be upheld on any reasonable ground. It sounds a little bit like the presumption in a criminal case, doesn't it? Beyond any reasonable doubt. Well, the court, having held that strict scrutiny applies, it held that a dig into the statute and the reasoning analysis was appropriate, then said, well, we have to resolve all doubt in favor of the state. You see how these things conflict? They're conflicting mindsets. It's not the same to say on the one hand, we're going to dig in, they don't get any deference. If there's a lesser restrictive means out there, we're going to find it, use it, it's unconstitutional. And on the other hand, saying it's like a criminal defendant who's before a judge and the possible penalty is jail, we're going to resolve all reasonable doubt in your favor. That was 2-1. Two people said, yes, it's appropriate to use that. One said, no, it's not. This, I think, is important for a couple reasons far beyond the scope of this case. If you have a case that's a rational basis case, it's one of those lesser protected constitutional rights, and the court is applying a presumption of constitutionality, that's not as impactful as when you are burdening fundamental constitutional rights. Not just this fundamental constitutional right, all fundamental constitutional rights, and you're presuming that the state is sort of like a criminal defendant. That's a different deal. That changes the landscape of constitutional litigation, which is one of the reasons we got involved as amicus curiae. It has impact far beyond this case. This case is important. The spillover effect is really important. So that's the first thing that the court said. The second thing is it dug into the compelling interest. Now, I will admit, frankly, the state advanced the compelling interest. It answered this question, said, yes, we have a compelling interest because we have a need for a short ballot. If we have long ballots, multiple pages, there's problems at the voting booth, there's problems scanning it, voters get confused. We have problems with not only efficient administration of elections, but we have problems with voters getting, all wild-eyed, and they don't know what to do, and there's mass chaos, right? Well, on the one hand, I can see how that's an interest, how that's important. Just to me, my English ears pick up the word compelling. It doesn't sound compelling. A short ballot. If that's a compelling interest, then why isn't it compelling I'll tell you what's really simple is one candidate. That's really simple. One party gets on the ballot. One office. I mean, how simple is that? Maybe the Constitution says we got to elect 10, and certain other offices will put just those on there, and we'll put one party. That's simple. That's efficient. But there's something beyond efficiency. There needs to be something more compelling. Nevertheless, and I think this is, the Court of Appeals fairly said, it read the opinions of prior courts which have found that this is a compelling governmental interest. And so it was united on whether there is a compelling state interest being advanced in the line drawing process of ballot access. Where the court disagreed is as to whether it was a narrowly tailored, least restrictive means of advancing that interest. Judge Calabria said no. The two in the majority said yes, so that issue is ripe for appeal. The majority effectively held that the 2% requirement was the most narrow way to draw the line. And it said that the state has an interest in a preliminary showing of a substantial modicum of support among a party's followers. So before you get in the game, you got to show that there's at least some level of support. And it said in order to meet that, that's the target, 2% is the least restrictive way to get there. Now, if I were to ask for a show of hands, and I'm tempted to do this, but I won't, I'll wait till later. If you have suggestions for how you might accomplish that interest, and you can think of some, write me at my email address. I'd love to see them, because I bet there's lots of ideas of how to advance that with a less restrictive means. However, that's not really even the issue. In this very state, the same legislature has accomplished the same thing with less restrictive means in the past. We had a 10,000 vote requirement. We had a 5,000 vote requirement. We know how to do it in a less restrictive way, and if we don't, there are other states that do. We're 5 times the national average. So whether or not it's the least restrictive, that's one question. Another important thing to consider is the fact that we're doing it at present. In certain circumstances, we're letting people on the ballot with a lower signature requirement than the 2% threshold. Sometimes you just need 500. Now, I'll grant you that that's a little bit different animal than letting a party on the ballot. Letting a single write-in candidate on the ballot for purposes of minimizing ballot clutter, that's not so big a deal. If you let a whole party on, then you got a slate of candidates. I'll give you that. But do we know how to do it with a less restrictive means? I think we do. Well, that's in a nutshell the Court of Appeals decision. I'm sure I've missed some things, but that in a nutshell is it. There's a substantial fundamental right that's being infringed upon. Strict scrutiny applies. There is a compelling governmental interest. There may or may not be the least restrictive means, and there may or may not be a presumption of constitutionality that's appropriate in strict scrutiny. Our role in this case is before the Supreme Court of North Carolina. We've petitioned, made a motion to be heard as amicus curiae. They've granted that motion. They've not set a briefing schedule. They've not calendared it. I would expect it'll be calendared late spring, sometime in the summer. But we're glad that it's allowed us to participate because of the importance of the constitutional issues here, which I trust you all have a grasp of. As this goes forward, I urge you very much to keep an eye on it. to think about some of the issues that are being raised, and if you think it's appropriate, feel free to write me with suggestions. I'd love to hear them. But other than that, I don't want to forecast too much what's going to go into the brief, so I'll stop there. We're getting close to the end of our time anyway, and I'll take questions to the extent I'm able to answer them. I'd love to do that. Yes?
I have a question, but not related to this. One of my frustrations is seeing how our sovereignty, every state's sovereignty is just gone. You find it with term limits and such. Could there ever be a change where states will determine the structure of who they send to Washington, the length of their service, rather than top down, this is the way it is, because they are an armed employee.
Right.
They're not in the federal government, and I find
Right.
when they go there, they forget they're an armed employee.
Right.
And you know, that's the frustration, because you say, I sent him there and he's doing that? And because there's no sense of connection to our legislature. And I see the state legislatures, they seem indifferent, whatever they do. And it may have come about with the, I guess, was it the 17th Amendment? When senators became elected rather than appointed. A further disconnect to the people who sent them.
Well, let me answer that real briefly in two respects. One is a structural issue in terms of how representatives are sent to Washington. That would require a change of the United States Constitution. That can happen. We have a process for that. It's called amendment. It's not called judicial decision, but we go through that process. The second thing I think you address is somewhere along the personal responsibility, the sense of what I'm here to do in my office. And I've thought long and hard about that. If other folks have other suggestions, I don't know anything else than elect them, scrutinize them closely, and elect the folks and vote the bums out if they don't do what needs to be done. Yes?
What extent do what other states do in this area impact the decision-making of our judge? I mean, obviously, you point out 5 times the national average. You know, I voted in New York for years. Not only are there 9 candidates on the ballot, 9 parties on the ballot, but they allow double endorsement.
Yeah.
I mean, so you can see a person's name on the ballot 2, even 3 times, endorsed by different parties. Never confused me or anyone I knew. My mother went to 8th grade. She voted in New York all her life, never had any problem. So I'm just wondering how that impacts, our tradition.
Well, I think it is somewhat informative to our judicial officials. We are state of North Carolina. We're not the state of South Carolina or any other. So they look, the boundaries, the political boundaries are hard and fast, not just in terms of politics, but in terms of the nature of judicial authority that's out there for review as precedent. As precedent, we might review what New York did or what South Carolina did, but it's not binding. It can be persuasive in some ways, but it's not binding. What's binding is precedent that the North Carolina Supreme Court has issued on state issues, and if the federal Constitution dictates in other areas, that's binding as well. This, interestingly, and I'll just toss this out there quite briefly, this is a case based on the North Carolina Constitution. So the most binding precedent is decisions issued by North Carolina courts on North Carolina law. In the state's brief and somewhat in the brief of the majority, there's a whole lot of reference to federal circuit courts, federal district courts, reference to other states' laws here and there, and that's partly because there hasn't really been anything directly on point in North Carolina by a North Carolina court. But I think it's fairly wide open in terms of what a higher court would do in analyzing this issue. It's not bound by those decisions of other jurisdictions based on other laws. Yes, sir, in the back. You've had your hand up for a while.
I was wondering strategically, what do you expect going to the North Carolina Supreme Court? Do you expect a recusal along the lines of what the lottery case did and a no decision from the result? And then if you've been 5 years, do you plan for that? Is there a way to avoid that?
I can answer that very simply. I have no idea. And I understand the question. You have no idea. Those are case-by-case decisions, and you just have to wait and see.
Why not go to the FEC collaterally and let them address the same topic while this is going on? It's been 5 years.
Yeah, well, it's a case that's been raised under the state constitution, not so much the federal constitution. If you want to go to the FEC and raise issues of federal law, and you'd have to reframe this and bring a collateral action, which the parties litigating this may want to do. Darren.
What is the fundamental right of the court of town? Upon strict scrutiny, what was the fundamental right?
The fundamental right, and I've gone through this a couple times, perhaps those of you who have read the case can help me on this. It appears to be something more like a penumbra. It's rights that sort of speak to this issue of ballot access without speaking directly to the issue of ballot access. But more directly, if you have a right of freedom of expression, you have a right to be affiliated with a particular party, say, I'm of this party, whatever that means, for good or for ill, this is me. Or you have a right to associate with a particular political party, and you can't draw distinctions based on what you say about your political party, what you associate in terms of your political brothers and sisters in the party fold. You can't make those sorts of distinctions based. I think that's where the fundamental right is primarily arising. Yeah. Okay. Goodness gracious. Yes.
Once a party is recognized, do the candidates still have to gather signatures to get on the ballot?
Once they are recognized, no. No, once they're on, then it's the 2% going forward to be retained, which
But the actual candidate for a particular office?
it's the party that's recognized, so they can draw a slate of candidates.
Put anybody else.
Yeah, yeah, okay. Professor Taylor, yes.
Jason, I'm trying to, as hard as it may be, I'm trying to get into the mind of the majority. And I guess I'm coming up with two, grasping here, but two sort of ideas of arguments that I would have thought that they might have made. They have significant implications, negative ones I think, but nevertheless arguments that they might have made to be able to make the distinction between the Libertarian Party and other minor third parties, the two major ones. One would be that they're not really parties. That essentially, if there is this fundamental right of association, there's something about a political party that makes it sort of sacrosanct. And really what they're saying is that the other parties aren't really parties. They're so small, they're sort of kind of groups of like-minded individuals that don't meet this kind of notion of a political party. Or the other thing that they're saying is that there's something important about the Democratic and Republican Party nomination procedures, sort of pre-ballot kind of process, that it makes them very different from other political parties, that they do a lot of sorting out. I mean, you talked about sort of the efficiency of the ballot. They simplify the ballot. They have these sort of competitive nomination contests. But it's hard. It would be hard to make that case if minor parties did that. I mean, if I was here, you have libertarian primaries. I don't know the answer to that. Has there ever been?
We are required by North Carolina.
And as a practical matter, there have been libertarian primaries.
There has been one.
Okay. So that even that argument, you could say, well, the Libertarian Party has this pre-ballot kind of process. So
Yeah.
I haven't been familiar with the case, but we've already just knocked down
Yeah.
22 things I can think of that would enable any kind of compelling state interest to make a distinction between the Libertarians and the other minor parties and the two major parties.
Those are intelligent questions. I'm not sure they've been asked. The larger framework that's at work here, I think, and honestly, I am a little bit persuaded by the thought that we can't let everybody on the ballot in every election. I get that. That makes sense to me. But that's not really the question. The question is, where is the trigger? Where's the tipping point for when everybody's coming on the ballot and just the significant players are coming on the ballot, those with a significant modicum of support? What does that mean? I think that's appropriate. That's the best argument I think the state has made from a legal standpoint, but they haven't really addressed the question of how else could that have been accomplished. If not two, why not 10? Why not more? I don't understand that in the context of these legal arguments. Bob.
Listen, okay, we've got a fundamental right. We apply strict scrutiny, and then they come up with presumption, which I think is really unique. It strikes me as it obviously strikes you that a presumption and strict scrutiny are almost, if not exactly, mutually exclusive.
Yeah.
So my question is did they invent that for this case to get to the result, or did they have some place out there in the ether of the Westlaw system that gave them this clever idea?
They did. They did indeed. Many cases for a long time for constitutional questions talk about this presumption of constitutional enactment of laws. We hear it all the time when we go to oral argument. Your Honor, as you know, this may be a bad policy, it may be a bad decision, but whether or not it's constitutional is a good question, but you got to rule with us unless it's just clearly, obviously, painfully unconstitutional, which it wouldn't be if we were standing here.
What is strict scrutiny then?
Strict scrutiny,
You know, you're either looking at it carefully, or you're just saying, well, we'll just stop our inquiry here and presume it's okay.
yes, preacher, choir, gotcha. Yeah, all right.
So how do they explain that? How do the majority?
They really don't delve into it. I think what has happened, and I don't know this is me speculating, and I don't get a vote. I didn't run, and I didn't get voted in, so my opinion doesn't matter. But I think they just looked at all of the consistent line of cases in the past that apply to presumption. The state argued a presumption. They're used to the world of rational basis review in which presumption is the law, and they applied it here. But I don't. I think that guts strict scrutiny. Yes, Kathy.
Does this case raise any interest in any legislators that you know of on that issue of how they change your party registration if the party doesn't meet their standards? And how that, you know, is your right to association?
Yeah.
If they can do that, then why not just say that if anybody that's a Democrat or a Republican consistently does not vote, then they're no longer belong to that party?
Yeah. Well, the issue in the 1982 case, when they changed the law to say that if you sign the ballot petition, you're automatically changed in terms of your registration, that very question was at issue there, and the court struck it down. I'm not aware of it having been raised again, but it's a question. I declare this, and I'm de-enrolled by the state. The state can say, well, that's just an official de-enrolling, what you are in your heart and mind and soul, that's not changed, and you can still associate with whomever you want, you just have to do it afresh every year. They can say that, but I think that's a question. I don't know the answer. Not that I know of. Not that I know of, but that's not to say they're not out there. I wouldn't necessarily know everything on that. Okay, 1, 2, 3, and then we're probably getting close to the end here. Yes?
Has your case identified any opportunity and tactics that might be appropriate this year to circumvent access restrictions for the grassroots movement for the 2010 elections?
No. Not in the context of this case, not thinking that broadly. We're drilled into the legal issues. That's a fair question, but I think the answer to it is no. Yes, ma'am.
As a former legislator, the presumption that the North Carolina legislature acts in a constitutional fashion is more than slightly amusing. I hear you, Brian.
I didn't say it. I am laughing, but I didn't say that.
Adam wouldn't let me testify. We have not had an election of constitutional districts this century, and the two major parties seem to have largely lost interest in the fact that we are about to have another election with unconstitutional districts, which means when the new districts are drawn after the census, they will be drawn by people put in office in districts designed to be protected victims, if you will. Any chance any of the parties interested in your legislation realize what a disadvantage this will place those parties and everyone in the public at to have the redistricting election in unconstitutional districts? And the sort of follow-up, here's the hard question I'm getting to. If legislators intentionally ignore the direct instructions of the North Carolina Supreme Court and U.S. Supreme Court, are they subject to impeachment?
Possibly. I think you'd have a pretty high standard of proving intentionality in terms of violation of their oath. It seems to be a remedy that is harsh, but not outside the bounds for the oath that they take. I don't know the answer to the question. I'm just thinking through it with you. Yeah, good question, though. Yes, sir.
Hi. I'm Sean Hall. I'm the proud to have the first
All right, excellent.
On the plaintiff's list there. And I really appreciate the fact that you've seen in our case that there's a need to draw a line in the sand on strict scrutiny here. And I'm wondering, is that part of a trend that you see going on in North Carolina courts right now, or is this case unique, or the beginning of the slippery slope of losing what strict scrutiny really means?
Getting a strict scrutiny analysis and yet losing the case, do I see that as a trend?
Well, because what I'm hearing you basically saying is, if strict scrutiny really means anything at all, then it's got to be applied in a certain way here that the Court of Appeals failed to do. And that now there's a threat that the state Supreme Court will fail to do that too.
Yeah.
Is losing that strict scrutiny definition of strict scrutiny, I guess, is that something that is you're seeing in other cases? Is that a trend that's happening? Or
Not yet.
Is the beginning we have to stop it right now, or it could spread to other people?
Yeah, there are, in constitutional law, as in a lot of law, you're arguing toward nuclear war. This is the strategy, right? Both sides do this, right? This happens and that happens, and it's social chaos, nuclear war, dogs and cats living together. It's terrible, right? That's what you're pointing to. Sometimes that's legit. Sometimes it's a reach. This is one that I think if you're really starting to erode the standard of strict scrutiny, if that's coming from here down to here, which some of the presumption and the analysis have narrowly tailored, might be doing that. If that's happening, that standard of strict scrutiny is the highest one we've got for constitutional analysis. That's the strictest bar we have to protect all sorts of fundamental rights, not just ballot access, free speech in other contexts, free expression of religion, establishment clause cases, search and seizure. You name some of these violations, it's a serious consequence. So I think this is actually one where there is a straighter line, if you will, toward bad consequences in this decision. That's just an opinion. That's just me personally talking. Okay. We take one more. Darren, how are we doing? Okay, good. Yes. I haven't seen it. I've been buried in Libertarian Party versus State of North Carolina and State Board of Elections. But I'll be interested to see it. Yes, sir.
You've destroyed two of the things that I learned in public school.
I'm sorry. Only two?
One is that, I always thought that words mean certain things all the time, not what the court
Right.
says. And the other one is about constitutionality, the presumption of constitutionality. I thought that the courts were supposed to decide whether the legislation, a law, was constitutional or not. So you're saying that General Assembly of North Carolina could pass a law saying that there's only going to be one political party in North Carolina, and it will be the Democratic Party, and that would be presumed to be constitutional by the court.
Under this case, I think you would say, yes, there's a fundamental right that's been infringed on by saying there's one political party. Strict scrutiny applies. And under this case, yes, you get a presumption of constitutionality.
So there would be no recourse to Republicans, Libertarians, Greens, and everybody else, other than to either join the Democratic Party or...
Well, the question in that era, in that context would be, is it so clearly, obviously, positively unconstitutional that even with a presumption, it has to be struck? Now, maybe a court would come down at that, but that's the rubric that the court would have to employ in answering that question. There's a presumption of constitutionality.
I don't want to give any Democrats in the audience here.
Okay, well, thank you, folks. I appreciate it.